Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Now, it is commonly held among attorneys that the Ninth Circuit is the most liberal of the appellate circuits, and that if you can get a test case in front of them, you can usually use it to expand the Constitution's reach, at least until the Supreme Court has an opportunity to weigh in. Now, that's not a bad thing. One of the things that legal scholars talk about, and sometimes you have to ignore legal scholars, I'll be honest, but one of the things that they talk about is the great laboratory of the states. And one of the things that makes federal law unique is that you have 11 different circuits throughout the country, and each one of them gets to interpret the law for their circuit. So if they interpret the Second Amendment very narrowly in the Ninth Circuit, and they interpret it very liberally in the Fifth Circuit, you can't use that Fifth Circuit ruling in the Ninth Circuit with any force. They tend to pay attention only to the Supreme Court and to the law in their circuit. And so, for that reason, the only way to get the law fixed when one of the circuits messes it up, and unfortunately that does happen from time to time, is to take it to SCOTUS. And usually the Supreme Court is not going to take the first case that reaches it. It will usually wait to see if there are other opinions that bubble up through the courts to make the question important enough to answer. And that's just how our Supreme Court works. It is not always an error-correcting court. It tends to get involved only in those cases where there is an opportunity to really make important precedent. Now, I've said that it's a liberal court, and sometimes it's good to have a liberal court make liberal rulings. As someone who believes very strongly in the First Amendment, liberal rulings in extending the reach of the First Amendment have made it possible to dissent on critical issues. Now, while I deplore flag burning, it has been held to be symbolic speech, which is why a person who burns a flag cannot be prosecuted for it, even if they wouldn't be welcome at my house. The flag stands for that freedom, and thus when you burn it, you trample on the very right it stands for, but that's for a discussion for another day. The fact of the matter is, it's a good thing that symbolic speech of every variety is protected by the Supreme Court and by the First Amendment. And I also believe in liberal applications of the Fourth and Fifth Amendments. Fourth, of course, is search and seizure. Fifth Amendment is right against self-incrimination, that sort of thing. Anytime those are liberally applied, I think that's a good thing. And that's what leads us to our first case. But before we go there, let's take a look at the text of the Fourth Amendment, because that's what's at issue in this case. The Fourth Amendment says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Now, why is that important? Well, let's see if the case can tell us that. This is Snitko versus the United States of America. Like the rest of the federal circuits, the Ninth Circuit doesn't bury the lead, and it talks about Fourth Amendment and inventory searches. Now, the context of an inventory search, I should preface by explaining, if you are driving along on a suspended license and you get pulled over and the police officer decides to tow your car will be towed to an impound lot, and then the police will go through it and do an inventory search. They will inventory everything in the car so that when you get your car back, everything that was on that inventory will be in that car. Now, obviously, they could very easily falsify the inventory, but that's not the purpose of it. The purpose of it is to prevent them from having claims made against them for things that people lose but forgot that they've lost. At any rate, that's the purpose behind an inventory search. Well, this is a case that involved a place called U.S. Private Vaults. And U.S. Private Vaults is a company that essentially allowed people to rent safe deposit boxes in a way where they didn't have to put down a lot of information about who they were. Generally speaking, if you go to a bank, you have to tell them who you are, you have to give them social security numbers, and there are ID requirements and things like that. Well, USPV operated a business which rented these, and they didn't require a whole lot of information about the people who were doing it. And as part of an investigation into it for various criminal activities, a warrant was issued. Now, the search warrant explicitly did not authorize a criminal search or seizure of box contents and required the agents to follow their written policies to inventory items. And the box owners could then later claim their property after the search. So if you had items that were related to criminal activity, for example, if you were a drug dealer and you got followed to U.S. Private Vaults and you stashed, $300,000 into one of these boxes, well, the feds could seize that because they would, know which one you put it in because they got all of the video and that sort of thing. They could follow their criminal people in. They knew which boxes to look for, and those they would file a civil asset forfeiture against, in addition to using that as the fruit of the criminal activity, so that's what the government would use as evidence against them in court. But there were a lot of people who just wanted to have a safe deposit box that wasn't in a bank. And people did that because it's a lot easier to get into something like a private vault, which is open 24/7 and subject to certain things like iris scans and that sort of thing to make sure that only the right people get into it. And that didn't require a whole lot of information because, frankly, nobody really needs to know if I put money into a safe deposit box, why I'm doing that. That's my business. The government only has so much reach. So eventually what happened was after they went in and seized all of this, even though they said they were only going to do an inventory search, they filed civil asset forfeiture against anybody who had property in there. And when they filed these civil asset forfeitures against people who had legitimate property in there, they took them to court. And then in the course of things, the government realized they may have gone just a little bit too far, and so they returned the property to the people. But then the people continued to seek equitable relief, requiring the government to return or destroy records of the inventory search. Because again, the government doesn't need to know what I put into a safe deposit box if I'm not a criminal. If they're not going to use it against me in court, if they're not going to try to seize that asset because they think it is the fruit of criminal activity, they don't have a need to know it. The district court denied that relief, finding the government's inventory of the safe deposit boxes was a constitutionally proper inventory search. In part one of its analysis, the panel held that the inventory search doctrine, an exception to the warrant requirement, did not apply. So the Ninth Circuit saying, hey, you guys applied the wrong standard here. Inventory searches should not have been used or applied. And they said, look, one of the most important features of the doctrine is the existence of standardized instructions, which limit the discretion of officers and apply consistently across the cases. Here, in support of its warrant application, the government, in addition to submitting standardized instructions, also submitted supplemental instructions that were designed specifically for this raid, and the panel held that the supplemental instructions took this case out of the realm of a standard inventory search. In part two of its analysis, the panel held the government exceeded the scope of the warrant, which did not authorize a criminal search or seizure of the contents of the safe deposit boxes. And then one of the judges, Judge Smith, wrote separately to address the plaintiff's additional argument that the origins and rationale of the inventory search doctrine make it inapplicable to safe deposit boxes in a locked vault. Judge Smith would hold that given the greater privacy interest and implications to the rights of third parties, the inventory search doctrine shouldn't extend to that vault. Now, while they basically say that they gave an affirmed a judgment here or reversed a judgment in favor of the plaintiffs here, such that the plaintiffs got the relief, that isn't quite the full story. Let's take a look at a few things that the court said in the course of its opinion. First of all, they noted that after a trial on the briefs, the district court granted judgment in favor of the government, holding the plaintiffs' rights were not violated because the inventory search was not pretextual pursuant to the case law. Plaintiffs timely appealed. We have jurisdiction, and we reverse. So they go into the, USPV operated a business in Beverly Hills which rented safe deposit boxes to customers. Customers kept all the keys to the boxes. There was an iris scan, vault access, 24/7 electronic monitoring. Protection of customers' anonymity was USPV's main selling point. On its website, the company explained, "Our business is one of the very few where we don't even want to know your name." Now, obviously, that's pretty attractive to people who want to break the law, but it's also, a little bit attractive to people who just want to, have some privacy. So the government began believing that this was essentially a money laundering operation, and they got an indictment against the public vaults. And the indictment included forfeiture allegations which reflected a finding of probable cause to believe that certain items to be seized were subject to forfeiture, the nests of safety deposit boxes, and keys. The two forfeiture counts stated the United States will seek forfeiture of the property in the event the defendant's conviction under the counts of the indictment. And that was fine as it applied to the people who were breaking the law, but it wasn't quite so fine to the people who were just there using the boxes and who didn't have any criminal intent and whose property should not be subject to civil forfeiture. For example, any amount of cash over $5,000 was to be placed in an evidence bag and given a forfeiture identification number. Well, that would include people who had legitimate money in there, in addition to the people who had criminal money in there. So then the court goes through some of the people who had stuff in there. Paul and Jennifer Snitko, who used their private vault to store legal documents, watches with sentimental value, hard drive backups, coins, and jewelry. They used it because their bank had a waiting list for a safe deposit box and they live in a wildfire-prone area. Tyler Gauthier, who stored silver and other personal property. Joseph Ruiz, who stored $57,000 in cash and used it because he was concerned that the COVID pandemic would make it impossible for him to withdraw his funds from a bank account. Michael Stork and Jenny Verdon Pearsons, who stored approximately $2,000 in cash. Travis May, who stored $63,000 in cash and $100,000 in gold. All of these people had an absolute right to do that. So when the government filed these notices to basically take this property, they objected under rule of criminal procedure 41G, and they asked for a temporary restraining order. And the district court granted the application because the forfeiture notice, and this is in quotes, put bluntly, provided no factual basis for the seizure of plaintiff's property as needed to comply with due process requirements under existing case law. During the litigation, nearly all the plaintiffs and class members ultimately had their physical property returned. Now, normally, that would moot the case. The government moved to dismiss, arguing their action had become moot. But plaintiffs argued that their action was not moot because the government still retained records of its search. What's interesting about this case, in my opinion, is that there was some chicanery at the end of it. But to understand the chicanery, we have to get to one of the most important things that the court said in the context of this opinion. And here's what the court said. We note that it is particularly troubling that the government has failed to provide a limiting principle on how far a hypothetical inventory search conducted pursuant to customized instructions can go. At oral argument, for example, the government failed to explain why applying the inventory exception to this case would not open the door to the kinds of writs of assistance the British authorities used prior to the founding to conduct limitless searches of an individual's personal belongings. It was those very abuses of power, after all, that led to the adoption of the Fourth Amendment in the first place. So, that kind of language, in an opinion, tends to be off-putting to the federal government. They don't want to see any kind of language like that that says when you're doing this kind of thing, you're violating people's rights and you're kicking sand in the face of the founding fathers. But that's essentially what the opinion says. So having been at oral argument and they know that they weren't able to explain this, and that kind of ticked off the court, and they pretty much have a good idea where this is going. So at the end of the case, they file a motion to dismiss the appeal. And they say, we have destroyed all of the evidence of the inventory searches and all of that. We've given them all of the relief they've asked for. We now move to dismiss the appeal as moot. And of course, dismissing the appeal as moot would mean there's no opinion. And if there's no opinion, there's no precedent. And if there's no precedent, then they can do this again. They tried it with the wrong court. So what the court did is it essentially issued an order telling the district court on remand to grant the relief that the plaintiffs requested. And then, instead of dismissing the appeal, they published the opinion and said, we are overruling as moot, because they issued the opinion, the request to dismiss the appeal. And the reason they did that is so, if there's no opinion, there's no precedent, and they wanted this binding precedent out there basically to restrain the hand of the federal government, because a lot of times it just goes much too far. And when the government does a good thing, or when the circuit does a good thing and issues an opinion that's noteworthy and that protects American citizens' rights, we should champion it. And that's what I'm doing. They don't get everything right at the Ninth Circuit, but they get a lot right, and this is one of those things that they got right. So that's what I have for you today. If you have any questions about the opinion or its reach, feel free to reach out. You can do so by putting comments in the comments down below or email me at the address above. If you have the opportunity today, go out of your way to do something nice for somebody, and then catch me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.